Good morning. Today we are going to see an income tax judgment of Supreme Court. Civil Appeal number 3005 of 2022, Union of India versus Ashish Agarwal. As usual, this is also a very interesting judgment. Facts of the case, I don't want to go deep into the facts of the case. Simply put, the reassessment sections of Income Tax Act were amended with effect from 1/4/2021. But the Income Tax Department issued the reassessment notices based on the S12 sections. Section 148, all of you may be knowing. There were some notifications which were extending the limitation period. Many high courts held that the reassessment notices issued after 1/4/2021, because it got amended based on the S12 sections, which were unamended section or bad in law, and many high courts have quashed the notices. No, you cannot issue this notice. That is what the high courts have said. After 1/4/2021, no notice for reassessment can be issued without following the procedure prescribed under Section 148. That is the new section which was introduced. There is a prescribed procedure. Investigation to be done with the permission of the higher officer, notice has to be issued, opportunity of hearing should be given, etc. were there in that section. Along with the notice, it is mandatory for the income tax officer to serve the order under Section 148A. Actually, Section 148A is a game changer for simplifying the tax administration. The new provisions, being remedial and benevolent in nature and substituted with the specific aim and object to protect the right and interest of the assessee, and the same being in public interest, Supreme Court held, high courts have rightly held that the benefit of new provisions shall be made available even in respect of proceedings relating to past assessment years, provided Section 148 assessment notice has been issued on or after 1/4/2021. That is, Supreme Court approved that judgment. They said the aim and object is to protect the right and interest of the assessee. So they said, no, even if you commence assessment after 1/4/2021, the new provision must be applied. However, there is a small twist in this case. The Supreme Court held that revenue cannot be made remedialess and the object of reassessment proceedings cannot be frustrated. Because in this case, I think approximately 9,000, 10,000 notices were issued and were pending. The revenue due to bona fide mistake, Supreme Court held, the revenue due to bona fide mistake issued the reassessment notices under the unamended section even after the amendment was introduced with effect from 1/4/2021. Hence, high courts must have treated the notices issued under the unamended provisions as those deemed to have been issued under Section 148A of the Income Tax Act, subject to compliance of all procedural formalities. This is what Supreme Court said. Supreme Court said it is absolutely wrong to issue notice under the S12 provision after the new provision came into effect, but it still says the High Court should have construed it as if it has been issued under the new section. Supreme Court exercised its power under Article 142 of Constitution of India because already I told you that nearly 9,000 notices were issued by the IT department under the old provision. So Supreme Court held that notices issued to assessees under the unamended section shall be deemed to have been issued under Section 148A of the amended section. The requirement of conducting an inquiry under the new Section 148A was dispensed with as a one-time measure from 1/4/2021 to 4/5/2022. That is the date of judgment. Then Supreme Court permitted the assessing officers to pass orders under Section 148A, and all defences available to the assessee were kept open. Supreme Court said that its order is applicable pan India. This is what Supreme Court said. Thank you very much. We will see later.